there's no cure for, but what I'm saying is,
oh yeah,
we get to that window where we can start making contact again,
oh
physical
yeah,
contact.
oh yes. I'm looking forward to it. I'm gonna put myself back on mute.
Yeah, got it.
Okay, are we all set? Well, good morning, everyone. My name is Diana Moya. I am the South Bend Human Rights Commission Director, and I'd like to welcome everyone to the Commission's webinar training this morning. And our topic today is about sexual harassment and the Fair Housing Act. In our webinar today, we will learn that sexual harassment and other types of discrimination is illegal. And our guest speaker for today is Lon Melteson. He is the Regional Director of Region 5 of the Office of Fair Housing and Equal Opportunity for the U.S. Department of Housing and Urban Development. Before we get started on this morning's agenda, I'd like to share that the webinar is being recorded. And if you would like to view the recording, the link can be found on the City Commission's webpage. Also, we will have a question and answer session at the end of Lon's presentation. During that time frame, you're more than welcome to leave your question in the chat area. We will email you a response if we are unable to answer your question during the webinar time. Of course, you may always reach out to the Human Rights Commission, and you can direct your questions to staff. We can be reached at 574-235-9355. Okay, and so without further ado, I would like to turn this over to Lon. Good morning, Lon, and thank you for joining us.
Well, thank you very much for having me, Diana, and I want to thank the South Bend Human Rights Commission for putting on this webinar and for inviting me here today. I'm honored to be here on behalf of the U.S. Department of Housing and Urban Development. So as Diana has indicated, my name is Lon Melteson, and I'm the Regional Director for Region 5. For those of you who may not be familiar with Region 5, we comprise the 6 upper Midwest states of Minnesota, Wisconsin, Illinois, Indiana, Michigan, and Ohio. And as Diana has indicated, today I would like to be sharing some information with everyone regarding the general coverage of the Fair Housing Act, as well as getting into specifics in terms of the prohibitions against sexual harassment in housing. And then I want to talk a little bit about COVID-19 issues dealing with discrimination. So with that, I'm going to go ahead and pull up my PowerPoint here. So give me a second. Takes a minute to load, so a second. All right. So let's kind of get started here. So as I indicated before, I want to talk just briefly about the Fair Housing Act and the various areas of coverage under the Act. Obviously, we only have 30 minutes here today, so I can't get into all the details of the Act. It's quite expansive of an Act. But I just kind of want to give everyone the general overview of what the protections are under the under the Fair Housing Act. And then I want to get into the specific issue of sexual harassment, because that's an area where we're seeing a lot of issues coming up that people generally aren't aware of what their rights are and what the protections are. And for the housing providers out there, what their obligations are to address sexual harassment in the housing context. And then lastly, I want to talk a little bit about COVID-19 and some of the discrimination issues we're hearing about in the region. So with that being said, let's dive into the Fair Housing Act. So the Fair Housing Act is going to apply to, generally speaking, residential housing properties. So it doesn't apply to commercial properties. It applies to housing that's either being occupied by an individual as their residence. So under the Fair Housing Act, it makes it illegal in the sale or rental of housing to take any one of the following actions: to refuse to rent to someone, to sell to someone, or to negotiate for housing. It also covers falsely stating that housing is unavailable. So if you go to an apartment complex and you see a for rent sign and you inquire about renting an apartment in that building, and you're told, oh, that property has just been rented, when in reality it's still available, that would be prohibited under the Act. It also covers prohibiting different terms, conditions, or services or privileges connected with that real estate transaction. So if they do rent you, but they charge you different rent or different security deposit, or they limit your access to some of the common areas that other tenants are given access to, those could be potential violations of the Fair Housing Act. It prohibits imposing different qualifications, fees, or pricing. It also prohibits discriminatory advertising or statements. So if someone were to advertise, sorry, we don't rent to families with kids, that could be a violation of the Fair Housing Act. It also covers discrimination in lending. So it prohibits mortgage companies from refusing to refusing to provide a mortgage to someone to purchase a home. It also includes refusal to provide loan information to someone, or imposing different terms or conditions of those loans based on a protected basis. So if a mortgage company were to say, well, we're going to lend to you, but we're going to charge you, but they end up charging you a higher interest rate than someone who's similarly situated in a different protected category, that could potentially be discrimination under the Fair Housing Act. It's also illegal under the Fair Housing Act to threaten or to coerce or to intimidate someone or interfere with them for exercising their rights under the Fair Housing Act, or for assisting somebody else in exercising their rights. And this would include retaliation. So if someone were to complain about discrimination, file a complaint with either the South Bend Human Rights Commission or the U.S. Department of Housing and Urban Development, and then are retaliated against for taking that action, that would also be prohibited under the Act. It also requires housing providers to provide reasonable accommodations and modifications to persons with disabilities. And just briefly, a reasonable accommodation is going to be an exception to a policy, practice, or rule that a housing provider has that would allow a person with a disability to equally enjoy the property. A reasonable modification is going to be a structural change that needs to be made to the property to make it accessible to a person with a disability. So to give you kind of an example of what those two items are, let's assume, for instance, say we have a three-story condominium building, and we have an individual who uses a wheelchair who would like to purchase a second-story condominium unit on the second floor. And in this building, there's a common stairwell that the tenants or the residents use, and then in the back of the building, there's a service elevator which the maintenance staff uses, and that service elevator can only be used by the residents when they're moving in and out of the building, but they cannot use it on a day-to-day basis. All right, so under those circumstances, our person who's looking to purchase it, who uses the wheelchair, could ask for a reasonable accommodation, which would be an exception to the policy which prohibits the use of the elevator, to allow them to use the elevator on a day-to-day basis, which would then give them access to the second floor unit. So that would be an exception to a policy that the housing provider has to allow that person to equally enjoy the their unit. Now let's take, for instance, let's say that person, instead of wanting to use the elevator, they would prefer to install a chairlift in the elevator or in the stairwell that could take them from the first floor to the second floor. that installing that chair lift is going to be a structural change to the common areas of the building. So that would be a reasonable modification, because it's going to be a structural modification to the building that allows the person access and equal enjoyment of other unit on the second floor. So what are the areas that are actually covered for discrimination under the Fair Housing Act? Well, there's 7 protected areas. So the first is sex, the second is race, the third is religion, the fourth is color or skin color, the fifth is handicapped or disability, the sixth is familiar status, which is the status of having children under the age of 18 reside with you. It includes individuals who are pregnant or in the process of adopting children as well. And then national origin is protected as well. So in order for there to be jurisdiction under the Fair Housing Act, you need to have an illegal act, which is those items that I've described before, that is because of one of these 7 items. So because of a person's race, their sex, their religion, their disability, etc. So that's kind of an overview of the protections under the Fair Housing Act. Now I kind of want to dive in and specifically and talk a little bit about sexual harassment in housing. So the first point I want to get across is sexual harassment in housing is illegal. It's prohibited by the Fair Housing Act because it's discrimination against an individual based upon their sex. So no one should have to endure sexual harassment or degrading conduct in order to keep a roof over their heads. So what is sexual harassment? Well, sexual harassment generally comes in 2 different forms. The first form is what we call quid pro quo sexual harassment. And quid pro quo sexual harassment occurs when a housing provider requires a person to submit to an unwelcome request to engage in sexual conduct as a condition of obtaining or maintaining housing or housing related services. All right. So quid pro quo literally means this for that. So it's when a housing provider is going to condition some sort of part of that real estate transaction based upon the person's submission to some sort of sexual conduct. So for example, quid pro quo sexual harassment could be a landlord telling an applicant that they won't rent to them unless the applicant has sexual relations with the landlord. So that would be quid pro quo sexual harassment. The landlord is conditioning renting to them based upon their submission to sexual conduct. Another example could be a property manager who threatens to evict a tenant unless that tenant were to perform some sort of sexual act for the landlord. Okay, again, you have a landlord conditioning a housing related action, which is the evicting of the individual, or preventing the eviction of them, conditioning that upon submission to sexual conduct. So again, that would be quid pro quo sexual harassment. Another example could be a maintenance man in the building who refuses to make repairs for a tenant unless that tenant submits to some sort of sexual conduct for the maintenance man. That would be quid pro quo sexual harassment. Another form of sexual harassment is what we call hostile environment sexual harassment. And this occurs when a housing provider subjects a person to severe or pervasive unwelcome sexual conduct that interferes with the sale, rental, availability, terms, conditions, or privileges of a housing or housing related transaction or services or financing. So this is going to occur when you have the housing provider engaging into conduct that just makes the tenant feel uncomfortable. They may not be conditioning any kind of action based on submission to sexual conduct, but the landlord is making this environment that's sexually hostile. It could be, for example, landlord constantly groping a tenant or trying to kiss a tenant. It could be comments that the landlord keeps making to the individual that makes them uncomfortable. Or it could be, for example, a maintenance man who's submitting unwanted text messages or pictures to the tenant that makes the tenant uncomfortable. So all this conduct would make the environment hostile for the person based on sexual harassment. So a general ingredient for sexual harassment is whatever the conduct is, it has to be what we call unwelcome. So so the person has to find it to be objectionable. Now, even though it has to be welcome, the fact that a person may submit to the conduct does not necessarily mean that it's welcome by the individual. And so this is a point that I want to emphasize, because when we're dealing with especially quid pro quo sexual harassment, where a housing provider is more or less threatening a tenant that unless they submit to this sexual conduct, they're going to suffer some sort of loss of their housing or loss of a privilege related to their housing if they don't comply. So under those circumstances, even if the tenant complies with it, as long as they're complying because they're feeling compelled to, not because it's based on free choice, then that would still be unwelcome. So how do you determine if it's a hostile environment? Because as I indicated before, a hostile environment is going to be made up of a pattern of conduct by a housing provider that creates a hostile environment for the individual. Well, generally, what we're going to be looking at is we're going to look at the nature of the conduct. What is the actual conduct that's occurring? We're going to look at the context in which it's occurring. We're going to look in terms of the severity, the scope, and the frequency of it. Is it something that's happening every day or on a constant basis, or is it an isolated incident? We're going to look at the relationship of individuals involved. If you're dealing with a landlord and a tenant, that's going to be very different from a situation of maybe a tenant and a tenant, or a visitor to the property and a tenant. And then we're going to look at the severity of it. So under some circumstances, a single incident, if it's severe enough, that could constitute a hostile environment by itself. So we look at these on a case-by-case basis. So if anyone is feeling that they're subjected to a hostile environment as a result of sexual harassment, they should certainly contact our agency or the South Bend Human Rights Commission and file complaints so that we can conduct an investigation to determine whether these factors have been met in the case. Now, another emphasis I want to get across is that the victim doesn't need to experience a loss of housing or any other tangible economic loss to be able to file a complaint of sexual harassment. So even though the landlord doesn't get, or the tenant doesn't get evicted, if they're being subjected to a hostile environment, or if they've been being put pressure on them to submit to sexual advances, that's enough for a victim to be able to file a complaint with us. All right, so if there's any housing providers out there, I want to talk a little bit about what are your duties to prevent sexual harassment in your buildings and in your property. And so first and foremost, a housing provider has a duty not to engage in sexual harassment. And that may seem obvious, but I want to emphasize this point that a housing provider by their very nature is in a position of authority over a tenant, and by engaging in conduct of a sexual nature with a tenant, even if you think that tenant may be voluntarily engaging in that, there's always going to be a question as to whether it truly is welcome by the tenant. So the bottom line is housing providers should not be engaging in sexual harassment of their tenants. But in addition to that, a housing provider has a duty to ensure that their employees and their agents aren't engaging in sexual harassment. So if they have a maintenance staff, they have an obligation to make sure that maintenance staff isn't sexually harassing tenants when they're going into the tenants' apartments to do repairs or to make maintenance or other items in the building. So what are some of the best practices for a housing provider? Well, first and foremost, they should have a policy in place prohibiting sexual harassment. They should make it known that it's prohibited, and tenants should be aware of that, and their staff should be aware of that. And they should develop processes for where applicants and tenants can report sexual harassment. And then they should apply sanctions for employees and contractors who do engage in sexual harassment. So if someone does report sexual harassment to them, they should take it serious and investigate it, and if it's indeed occurring, take the appropriate action to stop it. And they should educate their employees, their staffs, and their residents regarding these policies and what the obligations are under the Fair Housing Act. And then they should enforce these policies. You know, a housing provider can have all the policies in the world, but if they don't enforce them, they're meaningless. So it's very important for housing providers to not only have these policies in place, but then enforce them when necessary. So what should a person do if they are being sexually harassed in their housing? Well, they can file complaint with HUD. We have a 1-800 number that I have on the screen here. It's 1-800-669-9777. They could call our hotline number. We also have a TTY number, 1-800-927-9275. Or they could go directly to our website and make an online complaint. They could also contact the state or local agencies in their office, in their region as well, like the South Bend Human Rights Commission. If you feel safe doing so, you can tell the harasser to stop. You can make a complaint with your housing provider if they're not the harasser. And then, as I indicated before, it's unlawful to retaliate against a person because they made a complaint. So people should not be afraid to come forward and make a complaint. And even if it's unlawful to retaliate, even if that underlying sexual harassment complaint is deemed to be insufficient to constitute sexual harassment. So I want to kind of emphasize this point. So if someone comes forward, they think that they're being subjected to a hostile environment, they file a complaint with HUD. We do our investigation. As I indicated before, we're going to look at those factors. Even if we were to determine, well, it just doesn't rise to the level of sexual harassment, so we end up dismissing the complaint, the person's still protected from retaliation. So if the landlord were to retaliate against an individual because they made the complaint, that would be a separate violation. So a person shouldn't be afraid to come forward, be concerned that, well, what's going to happen if my complaint gets dismissed? Because even if the complaint gets dismissed, you're still protected. So what are the remedies out there if you are a victim of sexual harassment? Well, you can recover monetary damages. This could include loss for if you have to find a new apartment, moving costs. It could be emotional harm that you suffered as a result of the harassment. You're also entitled to equitable relief, which is judicial remedies developed by courts to prevent sexual harassment from occurring. If you have to get an attorney to represent you, you could be entitled to your attorney fees. And then the Fair Housing Act also provides for civil penalties against the housing provider if they violate the act. So I have a few minutes left. I just kind of want to quickly talk a little bit about COVID-19. and some of the housing discrimination that we have concerns about or that we're hearing about in the region. And the first one is dealing with sexual harassment, that we're hearing some reports that landlords are trying to take advantage of the COVID-19 situation by sexually harassing tenants. It's our experience that while a victim of sexual harassment could be anyone, generally the victims are people who are in vulnerable situations. And so if someone, because of COVID-19, if someone's lost their job, or if they're having difficulty finding other housing because of the stay-at-home orders and the various other restrictions related to COVID-19, that can make a tenant to be very vulnerable and susceptible to sexual harassment. So we have a lot of concerns about that. So if you are being subjected to sexual harassment, make sure to contact HUD, and we can determine whether or not a complaint can be accepted. We're also hearing reports of disability discrimination, where you may have people who have disabilities that make them vulnerable to COVID-19, and they're, as a result, that they're being subjected to discrimination because the housing provider may be concerned that they may be more susceptible to contracting COVID-19. Or we've seen situations where landlords are putting restrictions in place on the properties, and those restrictions could have an uneven effect on the persons with disabilities. So what do I mean by that? Well, right now we're hearing a lot of reports of housing providers who are prohibiting guests from coming to the properties. Well, if you have someone who's residing at the property who has a disability, that may require a home health care worker to visit the property, or it may require the person to have a housekeeper to come and maintain the house for them. So those situations can affect the person with a disability disproportionately, and they may be entitled to a reasonable accommodation to allow them to continue getting those services. And if the landlord doesn't make that exception for them, that could be a potential area of disability discrimination. We also have concerns about race and national origin discrimination, where housing providers may not rent to someone because, for example, the individual may be from China, and they're concerned that because the outbreak is worse in that country, that they may have COVID-19. So we have lots of concerns regarding potential discrimination for national origin discrimination and race discrimination. So if you're experiencing any type of discrimination, as long as it's related to one of those 7 bases, please contact our offices, and we can go ahead and determine whether a complaint can be accepted. And I would encourage all of you out there, even if you're not sure if it's related to one of those 7 bases, contact our office. We can get more information from you, and we'll assess whether it's something we have jurisdiction over or we don't. And if we don't, then maybe there's a possibility that we could refer to a different entity that may be able to assist you. So with that, I want to turn it over for questions. I see we have a few minutes remaining. So why don't we go ahead to the question and answer period at this point in time.
Hi, Lon. Thank you so very much. That was extremely informative. I will check the chat section to see if we have any questions, but currently I do have a question for you. And that would be, does the harassment always have to be perpetrated by a landlord or a property manager?
Good question, Diana. And the answer to that is no. That a housing provider is responsible for not only their actions, but their employees or anyone that they may have on the property under their control. And it could include other tenants as well. So if a tenant is sexually harassing another tenant and that housing provider is made aware of that and fails to take appropriate remedial action to stop the harassment, they could be potentially liable as well. So it's not limited to just the landlord themselves. It's going to be the landlord and whoever the landlord has control over, who's on the property doing the sexual harassment.
Okay, thank you. And then can the harassment be perpetrated by someone of the same sex?
Yes, it can. So the as long as the conduct is sexual in nature, then it could be potential covered under sex discrimination. So it could be a male sexual harassing a female. It could be a female sexually harassing a male. It could be a female sexually harassing a female, or a male sexual harassing a male. So the key is going to be, is it conduct of a sexual nature to bring it within the protection of sex discrimination?
Mm-hmm, mm-hmm. So I oftentimes when we get calls about the sexual harassment, some of the things that we share right away with the callers is that they need to tell someone about it. And oftentimes, sometimes we'll say, well, did you inform the person that was sexually harassing you to stop it, or that it was uncomfortable or unwelcome or unwanted? But, sometimes that might not necessarily be your presence of mind at the time that it's occurring. So what we tell people is, of course, to write it down, tell someone about it, but should they also at that time be contacting, say, for example, like the police department as well, concerning the action that's taking place? Certainly if it's egregious, but in that respect, what else, do we want to share with our callers when they're calling in about the sexual harassment, especially right now during this pandemic?
Sure. So if the sexual harassment involves criminal conduct, then they should, by all means, contact their local law enforcement entity, because they're the ones who can enforce the criminal law against them. So if there's let's say a sexual assault taking place in the unit, that's definitely, they should reach out to the local law enforcement. Then what we would say is they should always tell the harasser that it's unwelcome, as long as they feel safe to do so. Because that puts the harasser on notice that it's unwelcome conduct. And then if they feel safe, if the harasser is not the housing provider, so let's say it's a maintenance staff or another tenant or an employee, they should let the housing provider know, because they have to be put on notice and given an opportunity to stop the harassment before they maybe can be held liable. So they should do that. In terms of documenting what's going on, they should definitely keep a log. We encourage keeping a log, as well as the names of witnesses who might have witnessed it, because oftentimes, when it first occurs, there may be people there who can corroborate what's going on. Right. And if they don't write down those names of those witnesses, if it's 6 months later and now we're trying to do an investigation and they can't remember who those witnesses are, then it quickly become a he said, she said type of situation. Whereas if they're able to document who might have witnessed it, then it makes it easier for us to collect corroborating evidence that the conduct is occurring.
So have you, and I know that you mentioned earlier that currently we don't know percentage-wise what we might see with regards to any type of sexual harassment complaint filed, but the other question I wanted to know was, or the other question I have is, what about national origin? I know you mentioned that earlier. And what's happening? Is there a specific group that's being subjected to discrimination during this pandemic time?
So we haven't seen that many cases yet, but the concern is that with the coronavirus originating, for example, in China, that people may have a discriminatory animus towards people whose national origin is China, either as they're being blamed for the outbreak, or they may believe because they're from China or from Chinese ancestries, they might have been to China and be at greater risk of transmitting COVID-19, so they don't want to rent to them. So those are the type of concerns that we have. We haven't seen that many cases yet, but that's the underlying concern out there, that there may be this hostility or animus towards people based on, if they're coming from a country where there's a high number of outbreak of COVID-19.
Okay. Well, thank you so very much. We appreciate your time, Lon, for joining us this morning, a most informative session. And I thank everyone who joined us today as well. Certainly, if you have any questions and if we did not get to them, my apologies. You can always contact the Human Rights Commission at 574-235-9355. You can also contact HUD if you have questions with regards to any type of discriminatory actions taking place. And again, Lon, thank you so very much. We appreciate your time again, and thank you.
Well, thank you very much for having me.
Take care.
You too.